Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering college panics as fired professor's massive lawsuit takes on DEI. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Coming from the Daily Mail, Penn State professor sues the college after he claimed he was forced to teach that the English language is racist and the embodiment of white supremacy. Also from the Daily Mail, Obama-appointed judge says white Penn State professor can proceed with lawsuit alleging college's critical race theory trainings, including one that alleged white teachers are a problem, were racist and left him traumatized. Professor Jonathan Turley has commented on this case. The Atlantic has commented on this case. The best commentary on this case, analyzing legal issues and precedents, and giving us a great update on a recent ruling by the judge, is from Zatucci & Associates, attorneys at law. New court ruling sheds light on when workplace anti-racism or DEI training creates illegal reverse discrimination. Anti-racism training has been increasingly adopted in the workplace since at least 2020, often as part of employers' diversity, equity, and inclusion initiatives. Anti-racism and DEI training is very different than the kind of race-neutral anti-discrimination training that was once standard. Traditional anti-discrimination training was aimed at all employees with the intent of eradicating harassing or discriminatory conduct towards any protected class, whether race, gender, sexual orientation, or the like. Typical anti-racism and DEI training, in contrast, singles out just one racial class of employees, whites, as the source of all invidious discrimination against non-whites. The ideological underpinnings of anti-racism and DEI is critical race theory. The gist of CRT is that whites, by accident of their birth and skin color, are inherently privileged and inherently racist, since they supposedly benefit from the structural racism baked into society against persons of color. At an anti-racist employee training session, it's not at all uncommon to hear that whites are automatically privileged and racist against non-whites, regardless of any white person's individual history or conduct. And non-whites are automatically oppressed and incapable of racism, regardless of any non-white person's individual history or conduct. This is race essentialism at its finest, and as explained previously, amounts to illegal workplace discrimination. But because of the relative newness of anti-racism and DEI training, there's relatively few case precedents to rely upon in fighting it. Courts are just beginning to weigh in on anti-racism's legality in published opinions. In a recent decision, Piero v. Pennsylvania State University provides some much-needed guidance as to when anti-racist DEI initiatives and training creates a claim of hostile work environment under state and federal law. Generally speaking, this type of claim requires a plaintiff to allege that he suffered discrimination and harassment due to his membership in a protected class, in this case, race, that the discrimination and harassment was so severe or pervasive as to detrimentally affect him, and that a reasonable person of the plaintiff's race would also be detrimentally affected under similar circumstances. Both federal statutes, Title VII of the Civil Rights Act of 1964 and Section 1981, and state law, in Piero's case, the Pennsylvania Human Relations Act, require that the discrimination and harassment in a hostile work environment claim be sufficiently severe or pervasive to alter the conditions of employment and create an abusive working environment. But what does that mean in the context of an anti-racism claim? Let's take a look at the Piero case to find out. Frequent, required, and specific are key. Piero was a seasoned and well-reviewed professor of English and composition at Penn State-Abington. He sued Penn State for, among other claims, a hostile work environment due to his race, Caucasian, stemming from anti-racism training and initiatives mandated by the English department beginning around 2019. Penn State sought to dismiss Piero's suit as a whole for failure to state a claim. However, after reviewing the facts alleged in Piero's complaint, a judge for the Eastern District of Pennsylvania held that he stated a plausible claim for hostile work environment, allowing his suit to move forward in litigation. So the suit could not be automatically dismissed as Penn State wanted it to be. He will be allowed to move forward with his lawsuit and seek damages, which is exactly what he's doing right now. In her decision, the judge ruled that the discrimination and harassment alleged by Piero was severe and pervasive enough to withstand Penn State's motion to dismiss. Piero's complaint contains extensive and detailed allegations. However, the judge zeroed in on the following. So this is what she feels really matters, which is important because it's in front of her to make the decision. In June 2020, Piero was required to attend a conversation on racial climate, during which Penn's Assistant Vice Provost for Educational Equity, Alina Wong, led the faculty in a breathing exercise in which she singled out whites and non-blacks, so this was not for black employees, to hold their breath in longer than their colleagues. She stated that whites and non-blacks were privileged identities and needed to feel the pain suffered by George Floyd and caused by systemic racism. In the weeks that followed, Piero was informed by a colleague that resistance to wearing masks to prevent the spread of COVID-19 was, quote, more likely to happen in classrooms taught by women and people of color and to be led by white males. Piero received an email addressed to all Penn State employees from Anisha Smith, Director of DEI and self-described queer Christian cisgender woman of color. Ms. Smith stated that black and brown people are calling on white people to stop being afraid of your own internalized white supremacy. She further instructed white people to stop talking, yet also hold other white Penn employees accountable. In August of 2020, Piero's department chair and direct supervisor Liliana Naden, that's this lady, sent an email to all writing faculty espousing black linguistic justice. Specifically, Ms. Naden directed faculty to take measures to assure that all students see that white supremacy manifests itself in language and in writing pedagogy. A second August email sent by Ms. Naden asserted that reverse racism isn't racism. In October of 2020, Piero was required to attend a professional development meeting led by Ms. Naden and assistant teaching professor Grace Lee Amuzi. The pair proceeded to give examples of what they considered racist comments by professors to students. Only comments made by white professors were used as examples. These included a white professor asking about a student's native language or country of origin. Also, in October of 2020, Piero received repeat emails from a department colleague urging him to watch a video training titled, quote, "White teachers are a problem." In the video, a race activist assailed his white colleagues as the problem and claimed that white English kills people of color. What is he supposed to do with that information if he watches that video? It's insane. In November of 2020, Piero's interim division supervisor emailed all faculty to attend an Arts and Humanities as Activism event featuring Dr. Aisha Martinez. Dr. Martinez advocated anti-racism and critical race theory and condemned race neutrality, equal opportunity, colorblindness, and merit. According to Dr. Martinez, traditional scholarly standards such as objectivity were tools of white elites protecting their white supremacy. Department Chair Naden followed up with emails endorsing the incorporation of Dr. Martinez's form of anti-racism into departmental teaching. In January of 2021, Piero had to attend an anti-racist pedagogy meeting during which Department Chair Naden endorsed grading on the basis of race. In other words, applying more lenient grading standards to non-white students. So when universities adopt this standard of not only just changing their admissions procedures, but you have people like Ms. Naden making recommendations and obviously insisting that grading should be different based on your skin color or your gender. So how are you supposed to look at people in society and wonder, did you go through a college experience that allowed you to score grades that you didn't actually earn? So perhaps you're not that knowledgeable. Maybe you shouldn't be trusted if you look a certain way. These CRT and DEI strategies are destroying multiple professions simultaneously. And what an unforgivable thing to do to a student, to not allow a student to fail if they aren't prepared. Let the student earn the grade they actually deserve, and if they need to work harder, or if they find out a certain field isn't right for them, that's a good thing. We all need to find our place in the world. We don't need people to give us advantages that aren't really advantages. They're disadvantages. They're leading people down a path to failure. They may not fail a class, but they're going to fail in their professions. Piero reported the discrimination and harassment to Penn State through the school's bias report mechanism in the spring of 2021. In September of 2021, he met with the Associate Director of Penn State Affirmative Action regarding his report. She told him, quote, "There's a problem with the white race and that he should continue attending anti-racist programming, quote, until you get it." I'm at a loss for words about how sick and racist all of this stuff is, and I'm definitely going to keep covering it. In October of 2021, Piero attended mandatory training titled "White Instructors Confront White Privilege in Their Classrooms." During the training, Department Chair Naden presented material accusing white faculty of unwittingly reproducing racist discourses and practices in our classrooms. So for some key takeaways. First, Piero's allegations of bias were frequent. Keep in mind that these are more egregious, standout allegations the judge chose to single out from Piero's complaint. As is obvious from the foregoing, and was certainly obvious to the judge, the discriminatory and harassing conduct directed at Piero was not an occasional one-off occurrence. Indeed, the judge herself described it as a constant drumbeat. This certainly helps satisfy the legal requirement that a racially hostile work environment must be severe and/or pervasive. Second, Piero's allegations involve mandatory or unavoidable exposure to bias. Importantly, Piero was required by his department chair and/or Penn State administration to attend the meetings and trainings characterizing white faculty as inherently racist. He had no ability to opt out. Moreover, the constant drumbeat of these meetings and trainings, combined with the steady barrage of emails and comments from colleagues, made such racism an unavoidable part of working in the English department. Penn State effectively made it a condition of his employment to be subjected to bias upon his race. Again, this helps to satisfy the legal requirement of severity and pervasiveness of harassment such that his working conditions were negatively altered. Third, Piero's allegations involve specific and explicit instances of race essentialism. And what is the theory of essentialism? Essentialism is a broad philosophical concept that asserts that certain things have an inherent and unchanging nature. It is often used to refer to the idea of essence, or what something essentially is. It's inherent and unchanging. No, it isn't. They're just racist. But let's continue. In allowing Piero's hostile work environment claim to move forward, the judge stated, "To be clear, discussing in an educational environment the influence of racism on our society does not necessarily violate federal law. In allowing Piero's hostile work environment claim to proceed, the court does not contemplate that it is or should be the norm to maintain a workplace dogmatically committed to race blindness at all costs. Training on concepts such as white privilege, white fragility, implicit bias, or critical race theory can contribute positively to nuanced, important conversations about how to form a healthy, inclusive working environment. But the way that these conversations are carried out in the workplace matters. When employers talk about race, any race, with a constant drumbeat of essentialist, deterministic, and negative language, they risk liability under federal law. Thus, the judge was unwilling to call out critical race theory for what it is, reverse racism. Yet, in the very next breath, the judge held that Piero stated a claim for hostile work environment because his allegations specified bias against whites that was essentialist, deterministic, and negative. So the judge explicitly says, as far as she's concerned, employers can discuss white privilege. They can discuss white fragility. They can discuss implicit bias, even critical race theory. The problem is, and I don't necessarily agree with that, I don't think these discussions of race belong anywhere near employers and employees. However, that's a big hill to climb. The judge isn't concerned with that, but the judge is concerned with torturing employees with this on a non-stop basis. You can't surround people and try to brainwash them and force them to accept your ideas just because they happen to work for you. Her attitude is, sure, if you want to have a course, it's fine. But at the point where you start singling out employees of a specific race and you constantly berate them and push at them, that's not acceptable, and that can constitute a hostile work environment. Regardless, the lesson here is that any plaintiff hoping to challenge anti-racism in the workplace needs to allege specific and explicit instances of race essentialism, preferably supported by documentation. Piero backed up his allegations with emails, training materials, speech excerpts, and the like, all of which automatically equated his status as a white male with racism and intolerance, regardless of Piero's personal beliefs and conduct. Any would-be plaintiffs would do well to likewise keep careful records. Bias is tough enough to refute when it's documented. And from The Atlantic, a constant drumbeat of racial essentialism. A lawsuit alleging racial discrimination in Penn State's approach to DEI can go to trial and could shape the future of diversity programs on campus. Zach Piero, that's this guy, taught writing for 4 years in the English department at Penn State's Abington campus. Then he resigned and in 2023 filed a lawsuit alleging that administrators and other faculty members discriminated against him because he is white. In his telling, the school's diversity, equity, and inclusion initiatives violated the Civil Rights Act of 1964 by creating a hostile work environment. In response, hundreds of academics signed an open letter calling his lawsuit a reactionary attack on ongoing efforts in diversity, equity, and belonging. The dispute, like so many in higher education, pits a faction that believes the prevailing campus attitudes towards identity are racist against a faction that believes that they help fight racism. It's hardly unique in raising the question of whether DEI initiatives go too far. Still, this case stands out, not only because it resulted in a federal lawsuit, but because a judge denied Penn State's motion to dismiss Piero's hostile workplace claim. The case can now move forward. The ruling comes as a backlash against DEI initiatives is growing, and questions about when they violate anti-discrimination law remain unsettled. More significant, it establishes a standard that federal judges of varying ideologies could plausibly adopt, and that other plaintiffs can use to bring bias claims to trial. This could open the floodgates. This isn't a case where, say, a white Donald Trump appointee who hates academia took an extreme position like any departure from color blindness is illegal that would easily be overturned on appeal. This particular judge is more difficult for DEI partisans to dismiss. Wendy Beetlestone, a black district court judge born in Nigeria, was appointed to the bench by Barack Obama. She was announced last year as the University of Liverpool's next chancellor. She's clearly not hostile to higher education, and the substance of her ruling is hard for would-be critics to reject in full. Beetlestone sided with Penn State in dismissing multiple claims, such as Piero was subject to disparate treatment and that his First Amendment rights were violated. We are gratified by the judge's decision to dismiss the majority of Mr. Piero's claim, a Penn State spokesman wrote in an email. Quote, and we will vigorously defend the sole claim the court allowed to proceed. That surviving claim concerns whether Piero was subject to a hostile work environment. Penn State's approaches to race and DEI, as described in his complaint, plausibly amount to pervasive harassment, Beetlestone ruled. Whether or not Piero prevails at trial, Beetlestone's ruling could have an effect on how schools approach DEI. The kind of DEI programming described in Piero's complaint is widespread on college campuses. Now, lawyers may scrutinize that programming partly with Beetlestone's ruling in mind, and colleges hoping to avoid liability or costly lawsuits may study the fact pattern that Beetlestone saw as plausibly unlawful. If they're doing anything similar, they may reconsider. That's why people who see DEI initiatives as racist or aggressive are excited by this lawsuit, which was filed with financial support from the Foundation Against Intolerance and Racism, a civil liberties group, while supporters of DEI initiatives are lamenting this lawsuit. As the writers of the open letter criticizing the case put it, quote, we understand the stakes of this lawsuit, which regardless of its outcome will have a chilling effect on DEI and anti-racist initiatives throughout systems of higher education. College administrators should facilitate the free speech of professors, including vocal supporters and opponents of progressive DEI initiatives, regardless of race, not train or compel faculty to adopt essentialist or discriminatory views. Aside from all the legal questions about what constitutes a hostile workplace or discriminatory DEI initiative, institutions involved in these disputes ought to ask themselves, is diversity, equity, or inclusion really advanced by an administrator saying the white race has a problem, or by white professors being asked to hold their breath in order to feel pain? Legal or not, that sounds like prejudiced, alienating nonsense. This lawsuit is a critical lawsuit and is likely to change how diversity, equity, and inclusion is presented in colleges, but also in workplaces. We will definitely keep a close eye on this one. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another video. And if I don't see you, I will miss you.